Thank you, Chairman Issa, and thank you to the witnesses for your testimony today. When I drive from Georgia to Washington, D.C., about once every 6 months or so, and I get a chance to listen to the radio and scan and listen to all my favorite stations and tunes, I've got to pass through 3 states. I go through Virginia, go through South Carolina, go through North Carolina, and then I hit Georgia. And we all have had experience in crossing state lines before. And you'll have different speed limits and different levels of enforcement. You have the experience of figuring out what are the rules, or in other words, because you're going 79 miles an hour at the state line, and then flip to another state, and boom, all of a sudden the speed limit is 65. So you've got to then do, 74 to stop from getting pulled over, and hope that that officers won't stop you. But anyway, when some suggested earlier that we in Congress should preempt all state AI laws, they would not just have done away with states' nascent generative AI consumer protections, they would have preempted common law causes of action against AI companies as well. When the doctrine of caveat emptor, or buyer beware, ruled American jurisprudence, consumers had minimal protection and were expected to thoroughly inspect products themselves. Judicial interpretations began to change in the middle 20th century as products became less straightforward and more complicated. Common law developed to better protect consumers in products liability and negligence cases. Today, most Americans can hardly imagine taking apart a toaster, let alone an AI chat box, to make sure that it works correctly. But caveat emptor is effectively what advocates of a moratorium are suggesting we revert to when we talk about an AI moratorium. When you preempt an entire field of law, you're preempting the common law right along with it. Supreme Court law has repeatedly found, as it did in Regal versus Medtronic, that a federal law's reference to a state's requirements includes its common law duties. And in plain language, that means if Congress preempts state AI laws, we also preempt state common law, unless the legislation explicitly says something else. Common law cases to protect consumers are already being filed against generative AI platforms. 2 days ago, Senator Hawley held a hearing on the harms to children using AI technology, calling witnesses whose children died or were hospitalized after interacting with artificial intelligence chatbots. I know some of the parents and families are in the room today. Kristen Bride, Juliana Arnold, Mandy Furness, and Megan Garcia. I'm so sorry for what you all have been through, and I admire your commitment to justice. Common law is crucial to the protection of Americans because it exists no matter whether there are comprehensive state laws on the books or no laws governing new technology on the books. Even when there are no statutes, common law helps us set a floor for a standard of care as a society. When some of my colleagues across the aisle talk about a moratorium, preempting common law is exactly what they're talking about. Carve-outs might be offered for some areas of the law. Others may get a loose regulatory structure. But what many don't realize is that the glue that holds the law together would be wiped out in almost every scenario. By protecting common law, we can protect that floor that ensures every person harmed can seek to have their case heard before a court of law. This basic standard of care can spur innovation by preventing a race to the bottom. And it can offer a level of security as the federal government and states determine what the best next steps are for AI in the United States. And with that, Mr. Chairman,